Got it. Court does call the case People versus Daquan. Is it Hardick? Hardick?
And then on behalf of people, Your Honor. Under Natalie, for Mr. Hardick, who is not present, Your Honor, from no fault of his own. He is currently incarcerated at the MDOC Macomb Correctional Facility. It's my understanding a writ was prepared for the wrong facility. To that end, we're asking for an adjournment of the final settlement conference.
All right. I will adjourn jury final settlement conference to, what's my next date?
June 6th at 9 a.m.
June 6, 2025, 9 a.m. Jury selection will be June 9th.
Yes.
June 9th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
Bond continue. Court does call the case People versus Anatoly Zriski, I think it is.
Oh, and then on behalf of the people, Your Honor.
That's what I said.
It is.
I said it right.
You did, it's my ears.
Oh, okay. I thought you were
My mistake.
criticizing my pronunciation.
Assistant Public Defender Natalie Pate, with on behalf of Mr. Zriski, who stands to my right. Please state your name for the record.
Anatoly Zriski.
That's exactly what I thought. Isn't it, Alan?
Yeah.
All right.
Thank you, Your Honor. Today's the day you find such a final settlement conference. I believe the case is also on this docket.
Yes.
My client will be entering a plea to resolve both cases. He will be pleading no contest to the misdemeanor case, and in exchange, the felony case will be dismissed. That's correct, Your Honor, and there's agreement that he will be doing 5 years of probation on this case. That is.
So he'll be pleading no contest. I have reviewed that report to the stalking that's in 0330. And upon that case, the case ending in 1211 will be dismissed.
That is correct, Your Honor.
Right. And there's an agreement to 5 years probation.
Yes.
May I have him sworn?
Right. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you, man.
Anatoly Zriski.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of stalking. Is that correct?
Yes, sir.
All right. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is? All right. Two things about it I have to make sure that you understand. The first thing is that it, first of all, means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today. Is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe, well, I won't ask that. The court has been provided Pittsfield Township Department of Public Safety report for their case number 2403852 or 853, excuse me. Any objections to the court having reviewed that report?
No, Your Honor. Nothing, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of that offense. Counsel, have I complied with the court?
People are satisfied, Your Honor. Yes, Your Honor.
All right. Court will accept the defendant's plea of no contest to that charge. The case ending in 1211 is dismissed pursuant to the plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 21st at 1 p.m.
April 21st, 2025, 1 p.m.
Summarize briefly address bond where appropriate.
Sure.
Your Honor, I do understand that sentencing is set for pretty soon, it's on the 21st. We are respectfully requesting the court would consider modifying bond to a PR in this case. My client does state to me that he does have the support of his mother and that he has a FOC issue in Lenawee County he would like to take care of. With respectfully requesting the court would consider a PR bond at this time.
Okay, I'm not going to need a response. I'm not going to change the bond until such time as at minimum probation has talked to him. So I will look at it after that. All right.
Understood, Your Honor.
All
Thank you
right.
very much.
Thank you. Bond continued. Court does call the case of the people versus Nicholas Manahan.
And then on behalf of the Your Honor.
Good morning, Your Honor. Jeremy Clinton, on behalf of Mr. Nicholas Manahan, standing to my right.
I thought that was you over there.
Yeah, I'm here today.
You know, it's been a long time.
I like spending my Friday mornings with you, Your Honor.
Is that what it is?
It
Okay.
is.
He doesn't call, doesn't write, no phone calls, no. Anyway, what are we doing?
We have reached a plea in this matter. Mr. Manahan will be pleading to one count of domestic violence, no contest, under 769-4A. We've also reached an agreement as to the no contact provision. We agreed to no unwanted contact to facilitate parenting exchange between the parties after the no contest plea.
And that's correct.
Okay, gotcha. All right. Yeah, having sworn.
Raise your right hand. You solemnly swear affirm the testimony about the truth, the whole truth. Okay.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of domestic violence. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yeah.
Two things about it. I have to make sure you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. Do you understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead? Now, you understand that by pleading no contest, you will not have a trial of any kind. All right. You signed an advice of rights form today, is that correct? Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those, or pleading no contest, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 248566. Any objection to the court having reviewed that report?
Oh, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be May 5th, 2025, 1 p.m.
And Your Honor, if possible, may I ask the court if I could appear via Zoom that day? I will be out of town in Maryland, actually, with my wife.
I don't think he's going to be in Maryland. I think he just said that because
I really will be.
I think he said that just so I might say yes.
I may have seen the terrapin bug sitting there, but I.
Yeah. Okay. All right. Yes, we can. There's a form that you have to fill out and just submit it to us. We'll take care of that for you.
Thank you, Your Honor.
All right. Okay. So, and then as to the bond, I will amend the bond condition to. So my understanding is it will be no non-consensual contact for purposes of child exchange.
Yeah, and the co-parenting of.
Just the co-parenting. Okay, is there a circuit court or family court order regarding that, or
There is not, to my knowledge, there's a PPO that's expiring in the very near future, a couple weeks.
Okay, so the PPO says no contest,
Correct.
does not give a exception for,
Correct, and that expires, do you know the date? Early May, I can confirm that date with the court.
early May.
Yeah.
Okay, so even if I were to order it, I think the more restrictive order is going to apply. And so he would be, I don't want to put your client in a position where he's following my order and then violating the PPO.
Right.
So what I will do is I will grant that because the parties agree to that. However, I will not sign an order to that effect till after the expiration of the PPO.
Thank you.
Okay,
And
so
follow up with Ms. Welding, with the date of the expiration.
yes, once. So you can do it one of two ways. You can submit an order to the court now indicating that it will go into effect once you figure out the expiration date. Or you can wait to the expiration date, submit an order to the court, and I'll do it. So either way you want to do that. All right, fair
Thank
enough.
you, Your Honor.
All right, thank you. All right, enjoy Maryland.
Thank you.
Everybody's gonna get up here thinking I'll get my way if I just say that's where I'm going. Court calls the case, People versus Anthony Ned. Yes, he's in turn.
Good morning, Mayor. Please, Court, Your Honor. And Damien Cash on behalf of Mr. Anthony Ned, who is appearing in the court with me via Zoom by permission. Mr. Ned, state your name for the record.
Sir. All right, what are we doing?
Now, now that the prosecutor proceed, is there enough to go forward with charges?
Your Honor, at this time, people are unable to proceed.
Do you have a motion, counsel?
I do have a motion, Your Honor, my favorite motion. Your Honor, without being able to confront the accuser, I have motion to dismiss this matter.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Ned.
Thank you.
Court does call the case of the People versus Franklin Fisher.
And is it on behalf of Your Honor?
Please confirm, Your Honor, Robert Hamburger, R number P 14570. To my right is Franklin Fisher.
All right. Sir, state your name.
Franklin Fisher.
All right, what are we doing?
Your Honor, at this time, people are unable to proceed.
You have a motion for me, sir?
Yes, Your Honor, I would move to dismiss.
All right. People being unable to proceed, this case is dismissed. That's without prejudice. All right, thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Stephen, is it Grisbeck or Grisbeck?
Defer to the court, Your Honor.
And is it on behalf of people, Your Honor?
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Grisbeck.
Your name? Thank you.
We are doing the opposite of Mr. Cash's favorite motion this morning, Your Honor, which is we're going to be pleading guilty.
Okay. Pleading guilty to the charge of domestic violence. Has he signed an advisory form?
It's not, Your Honor. We went over that, but I will have him sign one.
All right, may I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Stephen Grisbeck?
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. Is that correct? That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that? Understanding of?
Here's a second concern.
You're correct. So, you'll be pleading to domestic violence second offense. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that, sir? All right. In understanding that, you still wish to plead guilty? All right. To that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Look at paragraph 5, you'll see it on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record, which is not anything, to get you to plead to this charge? Anybody threaten you or coerce you? You're doing this voluntarily, of your own free will, and because you believe that you're guilty of this offense? All right. September 2nd, September 2nd, 2024, at the location of 3121 Scenic Lake Drive, number 14, Pittsfield Township, Washington County, State of Michigan. What did you do regarding a Samantha Smith that makes you think that you're guilty of this offense? All right. And who is Miss Smith to you? Okay, so you have a child in common? All right. And you did that, the push was intentional, is that correct?
Yes, sir.
All right. And had you previously been convicted of a similar offense on or about May 24th, 2021? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 21st, 2025, 1 p.m.
Your Honor, I know I saw the bond argument like just before mine, and it probably takes some cues from that similar situation. It seemed like.
But you're not going to do that, right? No, go ahead.
Modify at least what I was going to say. We're hoping for release after he speaks with Miss Pollara. He's been in jail now for 2 weeks and a couple days, and
okay, so when probation gets down and speaks to him, they'll be able to give me some additional information to help me make the proper recommendation. The other thing that should be noted is his sentencing is about 10 days away.
Sure.
So,
And Your Honor,
yes.
people also wanted to add, if he is released, we would also like to add the victim's place of employment to the no-go to the bond conditions. If it's not already. I believe she changed her place of employment, what was originally on.
Did they give, well, on the original order, does it just say place of employment or does it give a specific address? Because it should be a general.
On our no-go to, at least on our bond form, it was only her residence.
Oh, it was only a residence. Okay, so at this time, what I will do is I will add to his bond condition, no go to victim's place of employment. All right, so I'll add that at this point, so that way if he's released, that will also be applicable. You understand that, sir? All right, very good. All right, thank you.
Thank you.
Court calls the case People versus Joseph Robbins.
And is it on behalf of people, Your Honor? Assistant Public Defender Natalie Pate, with on behalf of Mr. Robinson, state your name for the record, sir.
Joseph Robert.
Thank you.
Your Honor, at this time, people are unable to proceed. Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Right. Thank you.
Your Honor.
Court calls the case People versus Jeffrey McCullough.
Action on behalf of people.
Oh, hold on. Are they there yet? Oh, there. Good morning again. All right. Where are we on this case?
Your Honor, we are set this morning for a final voting conference, but this time people are unable to proceed.
All right. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Court does call the case of the people versus Yusuf Cyrus.
And then that's the people, Your Honor. Good morning, Assistant Public Defender Warren Brady on behalf of Mr. Cyrus. Would you like to please state your name?
Thank you.
Your Honor, at this time, people are unable to proceed. Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
All right, thank you. Court does call the case people versus Harley Hagan.
Ashley Lunch, the people. Good morning, Assistant Public Defender Warren Perry on behalf of the statement. Please state your name for the record.
All right.
Your Honor, this morning for final settlement, at this time, the people are unable to proceed. Move to dismiss, Your Honor, response.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Court does call the case people versus Shamari Pat.
And then on behalf of the people, Your Honor. Good morning. Assistant Public Defender Warren Kearney on behalf of Mr. Pat. Mr. Pat, please state your name for the record.
Smart that.
Your Honor, this time people are unable to proceed. Move to dismiss, Your Honor.
People being unable to, I can't do that. Unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you.
Court does call the case of people versus Jacob Spelling.
Ashley Lunch, the people. Good morning, Assistant Public Defender Warren Kearney on behalf of Mr. Spellings. Mr. Spellings, please state your name for the record.
Jake Spellings.
The owner is an outstanding offer in this case to plead to an added count 3 of operating while intoxicated first offense. I also understand the defendant is willing to stipulate to a bench trial, as are the people, so we're looking for a bench trial date, and that offer will be held open to the date of the bench trial.
Okay. Did he sign the form?
Yes.
All right.
Wait, I didn't.
Figures parity.
I know.
All right.
Really, I did see the form. I signed it. I knew we were.
Okay, sir, you signed this waiver of trial by jury form.
Yes.
All right. You understand that you have an absolute constitutional right to have the matter tried before a jury? All right. You understand that by signing this form, you're waiving your right to that to be tried before this court without a jury present.
Yes, sir.
All right. People also, for the record, waive their right.
We do, Your Honor. I have signed the form.
All right. Based upon the statement of counsel and defendant, court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for.
And Your Honor, I neglected to mention too, that waiver did come with a stipulation from defense to the foundation admission of the blood results. We don't have to bring in the nurse who drew the blood, nor the witness from Michigan State Police Lab.
All right. Very good. Is that correct?
That's correct, Your Honor, and the people are gonna keep the offer open. And I'll be sure to communicate with Ms. Swanby if things resolve.
All right. Non-jury trial, April 30th, 2025, set 9 a.m.
Yes.
9 a.m.
Thank
All
you,
right.
Your Honor.
Thank you. Bond will continue. Court calls the case, people versus Gaykick. Is it Bartanian?
Ashley Lunch, the people.
Bartanian, I think it is.
Assistant Public Defender Natalie Kate, on behalf of the team of Patio, who stands to my right. Please state your name for the record, sir.
Got it, budget.
Your Honor, we are set today for final settlement. At this time, people are unable to proceed. Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you.
Your Honor.
Court does call the case of the people versus Joseph Williams.
And then on behalf of the people, Your Honor. Good morning, Assistant Public Defender Warren Kearney, on behalf of Mr. Williams. Your Honor, Mr. Williams is not present. For the record, I asked for an adjournment.
I thought there was going to be more, but okay. Joseph Williams. You know, response bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash share. That warrant will issue immediately. Court calls the case people versus Tanae Wright.
Ashley Lunch, the people. Good morning, Assistant Public Defender Warren Kearney, on behalf of Ms.
right?
Mr. Please state your name for the record. You understand there set for final settlement conference, the defendant has proven to me that she's completed a parenting course, and people are going to be dismissed in this case.
No objection.
You don't have an objection?
Absolutely not.
All right.
I'd rather see you alone in person.
Wow. Should I? I should take offense at that, shouldn't I? No?
I think it's a compliment.
Is it?
Yeah.
Of course you're gonna say that. You're the quintessential advocate, Miss Graham.
All right.
Thank you.
This case is dismissed. All right. Good luck to you.
Yeah.
Court does call the case of the People versus Travis Oliver.
And is on behalf of the people, Your Honor. Assistant Public Defender Natalie Pate with an behalf of Mr. Oliver, please approach the podium. State your name for the record, sir. Sure.
Thank you.
Thank you, Your Honor. At this time, we wish to set this case for a bench trial.
All right. Is he signed off on the
He
form?
has, I did turn it.
Did you turn it into a summary? You have. All right. Sure. Okay. All right.
Sir, you signed this waiver of trial by jury form?
You understand that you have an absolute and constitutional right to have the matter tried before a jury. You understand by signing this form, you're waiving that right to be tried before the court without a jury present. People also, for the record, waive their right.
Yes, Your Honor.
Based upon the statement of counsel, and defendant court will consent to have the matter tried before without a jury. Non-jury trial in this matter will be set April 30th.
Yes.
April 30th, 2025, 9 a.m. Bond with its conditions will continue.
And Your Honor, I'm sorry, there was an offer that the defendant for be discharged with the sentencing under prosecution, but that will remain open until trial.
Trial.
And that is my understanding.
All right.
Thank you.
Very good. Thank you. Court does call the case, People versus Jordan Temple.
And then on behalf of the people, Your Honor.
Thank you, Your Honor. Richard Williams, presenting, feature 9583 on behalf of George Temple.
Oh, good morning. All right. Your name, sir?
Jordan Temple.
Thank you.
Your Honor, at this time, the people are unable to proceed.
Dismissed, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. All right. Thank you.
Thank you, Your Honor. Thank you.
Court does call the case, People versus Quranic.
And then on behalf of the people, Your Honor. Good morning, this is Mobile Defender Bartanian on behalf of the Sheik. Please state your name for the record.
Thank you.
At this time, Your Honor, people are unable to proceed. Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you, sir. Court does call the case, People versus Chiffon Hay.
After allowing the people. Good morning, Your Honor. Assistant Public Defender Bartanian on behalf of Ms. Hayes. Your Honor, Ms. Hayes is on her way. She got a little confused. She did come last week and then she mixed up her days. So she is on her way. This is going to be a dismissal. So I'm asking sincerely if the court will consider passing it.
Your Honor, I know that she was present in Judge Barr's court on Wednesday as a victim, so it is possible she didn't mix up the case.
Oh.
Did you already get the sticker out?
Yeah.
Oh.
I saw a pair and he looked like, oh no. So I said, fine.
Thank you, Your Honor.
Thank you, Your Honor.
You don't mean it, Barony. No, you don't. I'll pass it. Court does call the case, People versus Kyle Smith Blue.
And then on behalf of the people, Your Honor. Assistant Public Defender Natalie Pate, on behalf of Mr. Smith, states to my right. State your name for the record, sir.
All right. What are we doing?
Thank you, Your Honor. There's a resolution in this matter for my client will be pleading no contest to the charge of MDOB under 200 under a prosecutor's deferred.
And that's correct, Your Honor.
Less than 200. The 93-day offense.
Yes, Your Honor.
And then also prosecutor's deferred.
Yes, Your Honor, correct.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God? Raise your name. I, state your name.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of a building less than $200. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The fine could be increased at 3 times the value of the property destroyed. If that's greater than $500, that becomes the maximum fine. Do you understand that? All right. Do you understand what a no contest plea is? All right, 2 things about it. I have to make sure you understand it. First of all, means that you're not further desirous and wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead? Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? All right, look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty or pleading no contest, you'll be giving up those rights as well as all the rights of the form. You understand you're giving up your right to appeal of right? Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. Court has been provided and has been able to review Pittsfield Township Department of Public Safety report for their case number 208292. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the quote?
People are satisfied, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. That being the count 2, count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
May 5th at 1 p.m.
May 5th, 2025, 1 p.m. All right.
Your Honor, may I briefly address an aspect as to that?
Sure.
So Mr. Kyle Smith-Luke has some family in the Chicago area. Your Honor did previously sign a stipulation order that for some specific dates that he could travel to visit family. He is asking that pending sentencing, he be allowed to travel to Chicago to see family back and forth.
He likes his family?
I believe
No,
it was.
I'm kidding. All right. Any objection for the people?
No, Your Honor.
All right. Why don't we do it this way? I don't have a problem with him traveling to Chicago to see his family. Just prepare an order to that effect. I'll sign up.
Absolutely.
All
Thank
right.
you, Your Honor.
All right. Thank you. And I hadn't said this to the other individual. Make sure to stop down at probation on your way out there on the blast. Okay?
Thank you, Your Honor.
Court does call the case People versus Andrew McDonald.
And is that on behalf of the people? Good afternoon, Assistant Public Defender Warren Mary on behalf of Mr. McDonald, Mr. McDonald, signature record. Your Honor, I'm sorry, Your Honor. People are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you. Is that all? That all of them?
Hold on, the two that you did. I know two.
So are we ready on what's this one? Okay. Court does call the case People versus Deanna Gray.
And is that on behalf of the people, Your Honor? Public defender Naja, right, who is approaching. Thank you for the record, ma'am. Gentlemen,
Thank you.
you're at this time, people are unable to proceed. Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
You. Sorry, Nana. But Miss Parody needs to do that. Some of the other ones that need to. Who's on that? Eight?
Yes. I believe so.
Mr. Here.
But it's gotta be-
That's the one. Just what I need.
No. That's this one.
Oh.
Short. Ready, Andrew?
Walker. You're ready on that, on Walker? Court does call the case People versus Ariane Walker.
Good morning, Your Honor, after Lonnie for the people.
Good morning, this is Public Defender Margaret on behalf of Mr. Walker. Mr. Walker, please state your name for the record.
Thank you.
Your Honor, today's date time set for final settlement. We are ready to proceed. I do believe the defendant is going to be tendering plead guilty as charged to stalking with sentencing under the Home Dutiful Trading Act. In exchange for that plea, the people will not pursue potential bond violation that we learned about this morning from February. And that's it.
All right.
That's our understanding of the agreement, Your Honor.
All right, let's have him sworn.
Right, do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth?
All right, Mr. Walker, it is this court's understanding that you're going to be pleading guilty to the charge of stalking. Is that correct, sir? Okay. Now, that is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. You understand that? Okay. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Yes? I need you. All right. You have any questions regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right? Are you on probation or parole? No? Okay. Anybody threaten you or coerce you? Anybody promise you anything that hasn't been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. And also because you believe that you're guilty of this offense? All right. On the date of September 8th, 2024, at the location of Woodland Hills and Packard Road, Pittsfield Township, Washtenaw County, state of Michigan, what did you do regarding, is it your Danca Labrada that makes you think that you're guilty? Pardon? Well, what specifically did you do? Go ahead, Ms. Barrett.
Did you, follow behind, the alleged victim in this case? Did you have her consent to do so? Would it be reasonable that she would be frightened or terrorized by that behavior?
Had there been previous contacts between the two of you?
Well, Your Honor, I know there's one date on that, but this happened over a period of time. So, Mr. Walker, you would agree that it was more than one day that you walked behind her?
Okay, so you're walking behind her. There had been repeated occasions of you doing that? All right,
And those were after she asked you to leave her alone.
okay. That's the other thing that is.
I think the reasonable person, the only other thing.
Well, I think it was already asked by Ms. Parody. All right, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Judge.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation. for pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 p.m. 12 p.m. Bond with its conditions will continue.
President, the court will permit, will allow me to ask the defendant to stay in the court for just a few moments while she leaves. And get
Yes.
out here. Thank you
Yes,
so
that's
much.
fine.
I'll ask Ms. Endler to
All right.
check in with Deputy Allen.
So, sir, you'll need to have a seat. Don't leave the courtroom until the court instructs you. All right. Either myself or through my bailiff. All right. Thank you. Call the case, People versus Ryan Slay.
That's a lot of good people. Public Defender Natalie Kay on behalf of Mr. Slay, who is not present. Your Honor, I don't have an explanation for his failure to appear. I expect him to be here. We talked this week prior to this hearing. I did confirm that he would be in attendance in person. I don't know if something happened. I don't have an explanation for the failure to appear. For the record, I respect, we request an adjournment.
All right. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Cynthia Solomon.
After a lot of people. Assistant Public Defender Natalie Kate, from Solomon, who is not here, Your Honor. Your Honor, I do not have a he wasn't here today's court date. He did state she would be here in person. She appeared in front of Your Honor on Wednesday via Zoom for sentencing in another matter. She is currently pregnant. It is my understanding she was due that sometime the end of this month. I don't know. Either way, that could have something to do with her not appearance here today. That being said, I would respectfully request an adjournment. And for the record, Your Honor, I think this is at least her fifth failure to appear, and one of those was during the prior final.
Yes, I see that. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you.
And the PD's on both of these.
Thanks.
All right.
I don't want to take much.
That is. That is. Okay. Can I see then counsel on Rekovic and Courtright in chambers? Is that one PD that I'm taking out or both?
Both.
Both, okay. I know because you had to talk with somebody back with the interpreter.
Yes.
Okay, we'll make sure that happens.
Do you want me to do that first?
Now,
Okay.
let's get this done. First standing recess.
All rise.
And it was Raymond's case.
All rise. 14A District Court for County of Washington, State of Michigan, is now back in session. The Honorable J Cedric Simpson.
You may be seated. Court does call the case of the People versus Lori Anderson.
After one of the people.
Yes, I do go to Matt with the Anderson. She had one.
Okay, well, she's got to be here, so.
I
She
saw
won't-
her. She was. No, it's not her. She was here a few moments ago.
Just a few minutes.
Just, okay, I'll wait.
Just when you're coming in, she's got it.
Okay, all right. Thank you for sharing. All right, so,
Mayor, thank you so much for the Chambers conference in this matter. The people have become aware there were some videos that were not in our possession, nor the defense. So I've gotten those now just this morning, and I'll be disclosing them in due course to make sure that all discovery is complete before we move any further along with the case.
all right. And what we were gonna do in this matter then was to adjourn the jury final settlement conference. It'll be June 6, 2025 at 9. And then jury selection, if necessary, would be June 9th, 2025 at 8:30. And counsel, I will conclude it if would be assured that you've informed your client of that. Oh, no, here she is. Oh.
Yep, that is Miss Anderson.
Yep. Oh, come on out. We were kind of waiting for you. No, you can.
I'm sorry.
No, it's okay. So what we're going to do, there is video or alleged video that needs to be disclosed to your attorney. So that's going to be sent over. They're going to get that, send it over. So I'm going to adjourn the jury final settlement conference to June 6th, 2025 at 9 a.m. Jury selection, if necessary, would be June 9th, 2025 at 8:30. Both of those proceedings would be in person.
Thank you, Your Honor.
All right. Bond will continue. Thank you.
I
Yeah.
will send prosecutor Lisa that the defendant has with the.
Okay.
That's
So,
actually good.
so that does exist. Okay. Fantastic. All
Thank you so
right.
much, Your Honor.
Thank you. That it. We're in recess. We're in recess.
When I call your name, please. Malcolm Hanks and or Alyssa Robbins. I see the attorneys for Clara's House and Gardner Properties.
Yes.
Hussam Al-Musawi.
Yeah.
Thank you, sir. Ronald Fields. Mark Gaddy. Reese Palmer. Daryl Daniels. Mr. Chanis, I see you in Zoom.
Good afternoon.
Thank you. Todd LaFleur.
Here.
Thank you, sir. Miss Wilburn, I see you in Zoom.
Good afternoon.
Thank you. Soraya Patio. Here. Thank you, ma'am. Ashley Jones. Mr. Hughes, I see you in Zoom.
I think you have a conditional order of dismissal for that one that Min Kim sent in.
I do have it for the record today, yes, sir, but I don't have Miss Kim just yet. Rebar Herori? Yep. Thank you. Diana Lynch, I see you in Zoom. Angie Evans? Audrey Turner? Luvinia Kendricks Haynes? Here. Thank you, ma'am. Angela Stoker? Here. Thank you. Patrice Haywood? Here. Thank you. Crystal Stanley, John Stanley, or Jordan Haley? Sanji Spikes? Here. Thank you. Tiffany Roots, I see you in Zoom. Contessa Brown? Chanel Brown? Naja Washington? Angie Evans? Deanna Rogers? Yeah. Thank you. Mr. Daryl West, I have you in Zoom. Jasmine Branch? Here. Thank you. William Dunleavy? He's outside, he's here. Thank you. And are you Miss Winpoo? Yes. Thank you.
Welcome to the 14A District Court. I'm the Honorable J Cedric Simpson, and I'm about to provide to you valuable information regarding this current and other landlord-tenant. This is the landlord-tenant summary proceedings document. You are here for retrial. Your landlord has made allegations and claims that you should be evicted because you have not paid your rent or because they seek termination of tenancy or misdirection. After today, you will come back for an additional hearing and trial of the case. Yes, sir.
Did she tell you? Because these are two different people. Did she tell you what her power is? She did. Thank you. Appreciate it. Yeah.
In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and its Lynch Township is covered in this law. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at the first appearance, or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made, or 5 days after first being advised of these rights. You have the right to rental and other housing assistance. In 5 days of first receiving these advice, rights, and information, you must provide written proof to the court that an application for assistance has been submitted for process. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mish.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 74961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is area code 724-973-4500. Also, you may obtain housing assistance and other resources or coordinated entry resources. Their phone number is 734-5468. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside of court. The Michigan and local community dispute resolution programs are across the region. Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. To protect your credit and future rental possibilities, your case may be resolved by conditional dismissal and legal judgment, if that is approved by all the parties in court. It is important that you understand these rights. If you have any questions, please feel free to address the court.
Oh,
Washington State of Michigan is now back in session. The Honorable Judge J Cedric Simpson.
you may be seated. Gardenier Properties versus Claire's House LLC.
Nicole Jami on behalf of plaintiff, 85399.
Good afternoon, Your Honor.
Clifton Hitchcock, Linnell and Associates, on behalf of the defendant Clara's House too.
All right. And I have before me a consent judgment. Is that what we're doing today, folks?
That's correct, Your Honor.
Yes, Your Honor.
All right. And there's an addendum attached. Got it, and it is signed by counsel. I will enter the consent judgment. Thank you guys.
Thank you
for
very
working
much,
it
Your
out.
Honor.
Thank you, Your Honor. Have a
Have
good
a great
weekend.
weekend.
You too.
Sycamore Meadow versus Tyrod LaFleur.
Good afternoon, Your Honor. Jen Wilburn, P 83143 for the plaintiff.
Your name, sir? All right. And where are we on this case?
Your Honor, I checked with my client this morning. They are still in the process of switching over the software, so I do not have an updated ledger. In light of that, I would be requesting a 1-week adjournment, and then I do know Mr. LaFleur was working with Hawk, so I'm not sure where we're at on the rental assistance.
I don't have that person here. They were going to contact. Who are they contacting? The complexes, or were they contacting the attorneys for the complexes?
For,
Hawk, SOS.
my understanding is they were contacting the landlords.
Okay, they were contacting the landlords directly with the information. Have you heard anything from Hawk?
They waiting on, Sycamore.
Oh, okay, they're waiting on Sycamore Meadows to provide info. Got it. Okay.
Okay.
So let's see if we can sort it out in a week. I don't know, but April 18th, 2025 at 12 p.m. in person. Okay, thank you.
Thank you, Judge. Have a
Yes,
good
sir.
weekend.
All right, you too. What'd you
Thank
say?
you.
So I apologize for this, but that's what it is.
He wasn't here. Okay, I forgive you. All right, you have a good weekend. Court calls the case of Onyx Real Estate Solutions versus Ronald Fields.
Good afternoon, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
He's dialed in. Mr. Fields? You'll have to hit *6 on your phone. And that will unmute
Can you hear me?
There you go. Yes, we can
Hey,
hear
oh,
you.
How you doing? Good. How you doing this afternoon, Your Honor? Mr. Simpson.
I'm doing okay. Thank you.
No, I'm
All right,
sorry. Go ahead. I'm sorry.
It's all right. Where are we on this case?
Your Honor, this is
I thought I
of
lost
course,
y'all.
a termination of tenancy case with a month-to-month tenant. We're simply asking for possession back with a writ to issue by on or after April 21st.
All right. And Mr. Fields, what's your position on this?
So I got I got most of my property. I got to get important papers, my housing voucher and stuff like that. That's on there. I'm gonna go over and get it. I got problems with some people, and I don't want to, get myself into trouble. I'm like, I'm over there now at the my doctor's over here. Okay, just sitting around, getting my mental health situation. So, but hey, other than that, I'm gonna take this all the way on whatever to the end, because the guy that landlord, I'm talking about the attorney, the landlord, sorry, I don't know what's his part. He don't come and check in the house and none of that and see what's going on. He don't do nothing. He just said whatever. I've never seen him in my life. I think I explained it to you 2 weeks ago, the first time, remember? I don't have a car of my own, so I couldn't appear in person. I wanted to. I was trying to get my social worker to bring me up if they couldn't. They had something else they would do, so here I'm on the Zoom again. So, but I want to dispute this out. He ain't doing things right. I don't know what he's done. He's done some things he shouldn't have been doing. That's why, the house and whatever now is in a disposition it's in now. And I'm sorry to say it, but hey, things do happen. I'm going to do it the best way possible. I'm trying to find me somewhere to live now. Okay?
So you're trying to find somewhere to move?
Yeah, I'm having a struggle, man. I got a housing voucher and all that. It takes time around. It just don't happen
Okay.
overnight, one day overnight. But I'm doing my best. It's warm, the weather's warm up fine. It's cold out there still. Not as cold as it's been, thank goodness. I have better,
Okay, but Mr. Fields,
Yes,
how much time are you saying you need to move?
at least another 30-some days, man. I got my property in that household over at 213, I'm sorry, Maple Street, empty. Well, I was currently residing at, so I have some
I can give them
problems
to
with
the end
people.
of the month, Your Honor.
Huh?
Due April 30th.
Okay, I'll put that down.
Can you
Okay,
get
what's the next
yourself,
attempt, sir?
Mr.
I'm
Fields, can you
trying
get
to,
yourself
right now, I am. Go ahead.
Mr. Fields.
I got people yeah.
Okay, I haven't heard anything that's a defense to this, so I'm gonna grant a judgment, finding no tribal issue. Okay?
Okay.
Grant them a judgment for possession, but no writ until the end of the month, April 30th. So you got till then to get yourself out of there, okay?
Okay. Thank you very
All
much.
right. Very good.
Yeah.
You're welcome.
Anything else?
Nope, that'll do it.
All set? All right, have a good day, man.
You do the same, sir.
Mister.
Onyx Real Estate Solutions versus Mark. Is it Daddy or Daddy? Probably Daddy.
Good afternoon, Your Honor. For the record, Neil Chanis, appearing on behalf of the plaintiff.
All right. Daddy? No response. If you raise your right hand to be sworn, I can let you take a judgment. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
Thank you, Your Honor. Your Honor, we provided the defendant with a notice terminate the tenancy for recovery. I'm sorry, for a notice to quit to recover possession of property. We're asking for a default judgment for possession only with the writ to issue after April 21st, if that amount remains unpaid. I'm sorry, they haven't vacated.
There'd be no payment amount. I got you, counsel.
Correct.
Judgment to the plaintiff, that is by default for possession, no redemption amount, writ to issue 21st of April.
Thank you.
Onyx Real Estate Solutions versus Reese Palmer.
For the record, Neil Chanis, appearing on behalf of the plaintiff.
No, he's right here.
How you doing, sir?
I'm doing well. How are you doing? What's your name?
My name is Rich Paul.
All right. Hang on one moment.
I tried to get an attorney, sir, but it's such a short notice they wouldn't appoint me one. So I talked to my CMH worker, they paid my rent for this month. Even for Onyx Realty, they took out my check. I pay my rent every month. And I'm still mesmerized about what's going on, And I thought she'd be here today to interpret what's really going on. But I pay my rent.
Well, they're terminating your tenancy. You had a month-to-month lease, right?
Correct.
So when I first started.
That is correct, Your Honor. We could also give Mr. Palmer to the end of the month as well.
So they're terminating your tenancy, and basically what that means, Mr. Palmer, is they're asking you to move.
Okay.
Okay. So let me ask you this. You think you can get yourself moved by the end of the month?
I don't know that quick, sir, but I know if I get a little time, I can get another place. I'm working on it now. My CMS worker, I just got Section 8, and they're moving me to Ann Arbor.
Okay, so you just got Section 8.
I just got it, sir.
Okay, and so, right, okay, so, and you're with CMH. Okay, and so, did you ask them how fast you can get yourself moved?
Well, they're working on it, they're filling out the paperwork, and it's up to Ann Arbor Housing. But if you give me a little time, more time than the end of the month, because I'm paid up to the end of the month. But if I have to pay next month, then I can pay that, but I do need a little time.
Okay, so let me ask you this. When did you get your Section 8?
About a week ago.
Okay, so you got it about a week ago. So if I'm on the 11th, you got it about the 4th or 5th, somewhere around there at the beginning of the month?
Yeah, we went and picked the packet up from Ann Arbor Housing, and she's filling it all out now. And after that, we got to turn it back in. But they're gonna move quickly, I know that.
Yeah, they're moving quickly to try to get you housed.
Yeah.
Okay, so here's.
Also, I got a help home care provider that takes care of it. So I definitely need a place to stay.
Right.
Mentally incapacitated to do anything.
Okay.
You know, I need a person to take care of it.
Okay, so here's what I'm gonna do, and it may be a plaintiff's objection, but I'm gonna find that there's not an issue for me to try, and I'm gonna grant them a judgment for possession. But what I'm gonna do, instead of the end of the month, I'm gonna give you basically 30 days from the time you got your Section 8. So you got your Section 8 a week ago, so I'll make that the 5th of April. And so what I'll do is nothing can happen till May 5th.
That's fine, Your Honor. Sounds good.
Okay. You got that, Mr. Palmer?
Yeah.
Okay. So you make sure to tell they're gonna file a judgment with us. So you gotta make sure to tell your worker at CMH that, and also the people you're dealing with at Ann Arbor Housing, that this is the date you have to be out. Okay? You got that? Okay, real good. Okay, Mr. Palmer, good luck to you.
All right.
Good luck.
Take
Mr.
care.
Palmer. Thank you, Your Honor.
Onyx Real Estate Solutions versus Daryl Daniels.
For the record, Neil Chanis appearing on behalf of the plaintiff.
I'm doing well. Your name? All right. This is also a termination of the.
I have a year lease. I just signed.
You just signed?
Like 2 months ago. I'm okay. Then I get a letter from there legally.
Pardon?
I signed, paid my security deposit and signed a 12-month lease. Then after a month, maybe I get a letter saying that I'm there illegally. I'm like, wait, Simone, I'm here illegally. You got the money? I signed the lease.
Oh, that's right. This is.
So, yeah, if you look
Yeah.
at the notice,
Yeah, I see that.
yeah.
So. Okay.
Yeah, we have a situation where the city has, obviously, we are in the property, because it's in violation of the city ordinance, essentially voids the lease. And so we are.
Well, I don't. So but it was your client that entered into the lease.
That is correct. And after that, they received notice that they were in violation, specifically of section 122-441 of the zoning ordinance, regarding an illegal rooming house. We actually have a hearing scheduled for April 17th at 9 o'clock regarding this matter. They've actually requested that we go through this process. And that's why they adjourned the original hearing date.
Okay,
after all of this.
yeah, no, I get all of that. The problem is going to be that then you're asking your client signs a lease with Mr. Daniels. I'm going to just guess, go out there on a limb. I don't think Mr. Daniels drafted that lease, right?
Correct.
And that Mr. Daniels then paid monies to your client.
Yes, but he has
Oh,
not.
just hold
That
on.
is correct. When he moved, yes, the security deposit, first month's rent, I believe, maybe the portal's been turned off, but I think the last 2 months have not been paid, most likely because of the notice that he received.
So we love saying not to pay. But I still
Correct.
Okay, hold. Hey, hold on. Okay, so let me ask you this. Mr. Daniels, because you can't stay there for your lease or your year lease, it wouldn't look like you're able to because you're going to be in violation at some point. Well, the tenancy's in violation of the city ordinance. Is your client willing to give him back all his money he paid?
If that's what is required to allow him to move out, I can certainly make sure that happens. Now, that may just require, I think, January, the security deposit, and the February rent, possibly. I don't have that in front of me.
Well, did you pay February or no?
Yes.
You paid February. So you paid January and February and the security.
January, I came in 28th. January. And February, March.
So how many months rent have you paid? 2? Okay. So it looks like security deposit at 2 months rent.
That could be, I can double check that, Your Honor.
So let me ask you this, Mr. Daniels. If you get that money back, can you move yourself then? Would you be in a position to get yourself moved?
It's gonna be a process, but at the same time, these people, knowing that they didn't have proper paperwork and things in order to do what they did. So, negligently, dishonestly, took my money, you know, knowing what you had basic, you know, and then come to me a month later talking about I'm there legally.
Okay, so Mr. Daniels.
And pay the street hospital. Definitely.
And do what?
Pay the street hospital. But
He's paid a total, it looks to me, I think this might be accurate, of $1,150. That includes the security deposit.
So he's paid $1,150, including the security deposit. That sound about right to you?
Yes, sir.
Okay. So if you get your $1,150 back, how long would it take to move yourself, you think?
Judge, can I interrupt you? I'm Mr. Daniel, social worker at Housing Bureau for Seniors.
Yes, sir. Yes.
Yeah, so we just moved Daryl in, and House into Home put a lot of really nice things in his room. We're not going to be able to pay for a move into a new place. So we're requesting that they also help us with the moving costs, because there's a lot of nice stuff that's gonna not be able to be moved because we just paid to get it moved in there.
Okay. Here's what I'm going to do, folks. I'm going to set this for basically a final settlement conference for April 22nd. Is that right? Yes, April 22nd, 2025 at 9 a.m. Everybody needs to be in person, and then we'll just hash it out and figure out what needs to happen and try to get there. All right.
Before we go, Your Honor, Madden, if you can contact me with what you estimate or actually get a quote for moving what needs to be moved and the cost involved, maybe we can resolve this before the 22nd.
Absolutely, thank you.
You can probably find my information on his paperwork.
All right. Thank you, Mr. Daniels. You take care.
Thank you, Your Honor.
Thank you, sir. Have a great weekend.
You too. Thanks.
Arbor Manor versus Soraya Patio.
Good afternoon, Your Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Okay, I'm having difficulty. Well, I don't know. Mr. Hughes, can you speak again? Because
yes, can you hear me?
Yes, I can hear you now. Okay, thank you. Your name? And what's the claim now in this case?
Thank you, Your Honor. The claim is the rent that's due is $1,518, $165 in court costs, a total of $1,683. The last payment was made on March 19th for $150. Prior to that, there was a payment in January.
All right. Okay.
This is the last person I just got the job, so, you know, I don't get paid I don't want to get put out, I just need like as much time as I can get this so that I can get.
Okay, how much is your monthly rent?
$831.
Say again, Mr. Hughes.
831.
Yep. Okay.
I'm sorry, Judge. 531. 531.
531. Okay. Yeah, she looked a little bit surprised. So that's about the number she gave me. Okay. So you're 16 behind, and how are you going to get that caught up? I mean, or let me ask you this, when? I realize you're working now. Let me ask you this. You haven't gotten a check yet. Did you talk to Hawk at all?
I called him, I'm waiting for the call back from him first, the intake, I can also apply for the video, and I sent them. I have everything.
Okay, Mr. Hughes, did your client get any information from Hawk regarding this individual?
Not that I'm aware of, Judge.
Okay. But you haven't had an interview with Hawk yet?
No.
Oh. Okay. And you're waiting on something from them?
Yes, and
Okay, so let me ask you this. When's your first check supposed to happen for you?
is it okay if I take?
Huh?
Is it okay if I take?
Yeah, go ahead. If that'll give me my answer. So you don't get a check until the 25th. Okay.
If that's all the time you give me, I take it, I just need extra time.
Well, if I gave him a judgment today, you get to the 21st. Right? But
I can give her till the 25th, is that's what she needs.
yeah, but you don't even know what that check's gonna look like, do you?
No, but I got,
Other things that can,
I got. I'll make it happen. I got 2 babies. You're not gonna be out of the cover.
I am believing. All right, here's what I'll do for you, okay? Rather than clicking over into another month, I'm gonna find that there's no tribal issue. I'm gonna grant them a judgment for possession. The total amount including cost is $1,683.
Correct, Your Honor.
All right. $1,683. That's the total amount, okay? And I'll have the writ issued the 28th. Give you that additional weekend to, and because I don't know what time your check's gonna come in on the 25th either, right?
That's fine, Judge.
All right. Okay, thank you, ma'am. You do the same. Court calls the case Forrest Null versus Ashley Jones.
Paul Hughes, P31986, appearing on behalf of the plaintiff. Your Honor, you should have a signed conditional dismissal in your file. I don't think Min Kim's planning to be here. I happen to be here on other cases.
Oh, and this Kim, got it. So she had an attorney on it. Okay, I will sign off on that. My only question.
You have a release of escrow as an obligation to the court.
Yes. Okay. Great. Okay. Fantastic. The case is conditionally dismissed.
Thank you, Judge.
Forrest Null versus Rebar Herori.
Paul Hughes, P31986, appearing on behalf of the plaintiff.
Hello, sir. What's your name? All right. And what is plaintiff claim in this case?
Your Honor, the defendant owes $6,125, $165 in court costs for a total amount due of $6,290. His last payment was made on January 6th. His current rent is $1,390.
And Mr. Hughes, do you show a $1,411 payment on that ledger?
I show a $1,436 two payments on December 1st.
Okay, but we paid out the 1411 on just a couple days ago, so you guys don't have it.
I don't have it yet.
Okay. All right.
When you said you paid it out, is that from the court's escrow?
Yes, it was
Okay.
escrow that the defendant posted.
Okay. I don't have
So
that.
that amount goes down a little bit. All
Yeah.
right, sir, what do you have to say about this?
the court date I had I had different court dates, but they don't come. They said that I owe $471, but they don't know where they come from. So they've been after I signed the lease last June. After I paid the rent and I went there, they said they had to come for a new lease. After a couple months, they said I owe $471. Well, I went to the office. I said, "What is this for?" There was a gentleman there. He said he doesn't know what it's for until the manager comes. So I said, "Okay." And then next month, I went to pay a rent, and then I talked to there was a lady there. She said, the month of June, my rent went up to $1,411. I only paid $1,000. But my rent before that it was $792. So I said, "How?" They said, "You only pay $1,000." I said, "Either I paid $1,400 or I paid $792. There's no way I just give you $1,000." Because I made a money order. They said, "Oh, there's $477 missing."
So, sir, how much do you think you owe?
I thought I owed with April. Right now I owe $2,800. I can give you $2,800 for February and March. I have that. I can give it to them. And then
Where do you have that? You have 2,800?
Yeah, I would make money on. I was just waiting for the court, and I was gonna give it to them.
All right. And then how are you gonna pay the rest of it?
It just fell out this April. After that, it's only April left.
Well, no, because I have, so if I take this, you got court costs on it. So if I take the 6,290 minus $1,411, because they haven't gotten that payment. What do you?
$4,879.
That's what I get. Okay. So then you owe $4,879. You say you have 28 now, right? That you can give them. And so then you're gonna owe $2,079.
I don't, yeah, they add $477. I don't know where that $477 came from. The lady said it was for when I signed the new lease, my rent went up in June. I thought it was July. I asked for the copy of the lease.
Okay, but sir, just listen. If I take that 477 off, if that's what you're saying, I still have $1,600. When are you gonna pay? When can you pay that?
I can try to pay in a couple of weeks, or in May, sometime in May.
Well, that's not gonna work.
Okay.
Okay. So your whole dispute is over the 400 and some odd dollars, right?
Yeah. I don't know where they come from because they don't even know where they come from. They just said after I signed a new lease, they told me a couple months later they said I have a due amount of $477.
So what is the exact amount that you're saying that they can't figure out?
Those are the 477.
477.
Yep.
Okay. Here's what I'm gonna do. Mr. Hugh?
Yes.
I'm gonna find no tribal issue as to everything but the 477. I'm gonna grant plaintiff a judgment in that amount, whatever that, taking that 477 off.
Yep.
With the writ to issue the 21st. So you're gonna have 10 days to pay, sir. That amount. So it's gonna be an amount less the 477. You gotta get that paid by the 21st. The 477 is reserved for a future date to determine its origins.
Also, they have to come fix maintenance stuff. They haven't fixed it.
Have you submitted work orders?
Yep, I went to office several times.
Did you submit work orders?
Yes, I did. With them.
I don't have any of that.
Oh, yeah, okay. I did with the landlord. I mean.
Okay, well, then you'll have to continue to deal with them. But this amount's owed. I've reserved the 477. If that becomes an issue, we'll deal with it at a future date.
Okay.
But I'm gonna grant them the judgment for that amount, okay?
Okay.
Thank
What
you,
is
Judge.
that? 6290 minus 477.
I'll get it for you.
5813. So you got to pay $5,813 by the 21st. All right. Thank you. Courthouse case, Forrest Knoll versus Dana Lynch.
Paul Hughes, P 31986, appearing on behalf of the plaintiff.
And Ms. Lynch, state your name, please.
Dana Lynch.
All right. How much is owing, Mr. Hughes?
Thank you, Judge. The amount of rent due is $2,821, court cost of $165, for a total amount due of $2,986. The last payment was made on January 14th. I'm sorry. There was a payment recently made in April for $134.
Lynch, how are you intending on getting this paid?
It's approved, so it should be already in your system.
What?
Hawk already approved everything, so everything should be taken care of and paid off.
Okay. That's why you paid the 136 to get it below the 3,000. No,
that was just
Right.
my April's rent. Oh, sorry.
Oh, okay. But yeah, I get it. But it kept your balance down because otherwise it would have clicked over.
Correct.
But you don't have that payment, do you, Mr. Hugh?
No, not as of this morning.
Okay, so what I'm gonna do is this. This one I'm going to, because I don't have anybody here, and it would have been the landlord that would have been contacted with what Ms. Lynch is saying. I'm gonna adjourn this out 1 week to the 18th,
Thank you.
2025 at 12 p.m. And then let's see exactly where we are. Okay, Ms. Lynch?
All right, sounds good.
Pardon?
Sounds good.
Okay, thank you. All right,
You
have a good weekend.
You too.
Forrest Knoll versus Angie Evans.
Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Oh, I have two Angie Evans.
Yeah.
Okay, so which, do you live at Forest Knoll?
No, I was moving out of there and I needed,
Hold on.
I used to live at First North, I now live in here.
Oh, so hold on. Who's the,
So here on Vista is the other one. So here she has two cases with two different plaintiff attorneys.
oh, this is beautiful.
I didn't hear.
So she, I guess has moved, ma'am, you're telling me you moved out of Forest Knoll
Yeah.
and now you resided here on Vista?
Did she live
Okay.
at 1140 Lumber Street?
Did you used to live at 1140 Lumber?
I'm here for both cases. The Lumber Drive address, I just needed like 10 days to get my stuff, the rest of my stuff out. I have
Gotcha.
That's
Okay.
it, and I just wanted to close this out, but I didn't have anybody to help me to move my stuff from Herori Vista to, from Lumber to Herori Vista. And I have a disabled son, and on top of me losing my job, so it was just a lot. That's why I have to-
Okay.
And I
We'll
wanted
work
to
this.
close it out.
Okay, hold on a second. Let's do this. You need, and it's obvious she's moved someplace else. So you just need time to get your stuff out of.
Yes.
All right, so here's what I'm gonna do. And you surrendered that possession, so the landlord can take that premises back. All right. And that's really all that they're looking for. But what I'm going to do, rather than give her a judgment at this time, well, here's what I'll do. How much is owing total?
$2,106.
$2,106. Okay, I'll issue a judgment for possession in that amount finding no tribal issue, and no writ until the 28th. All right, that way that'll give you time to get your stuff out of there
And
and over
turn
here.
in, and have her turn in the keys too.
Yes, you got to turn in the keys once you're.
I actually lost the key. I was going to go there after here to get a cop. I know, everything is a mess, but
No, it's not. Okay. Okay, just listen. So you don't have keys.
no.
Okay. So when you get all of your stuff out, you need to make sure you go to the landlord, tell them I don't have keys. They may have you do something like sign off on something so they can change the locks.
Okay.
Okay, fair enough?
Yes.
That'll work out.
Thank
Okay,
you,
so I'll
Judge.
give you a little bit of time, get your stuff out.
Okay, you said that's the 28th.
Yeah, you have until the 28th to get your stuff.
Okay.
I know you said you needed 10 days, but I gave you a little bit of extra time because you're trying to move that and your son's stuff.
Okay, and do I still wait for the permits to call?
No, we're, okay. Is that it for Mr. Hughes or?
No, one more.
Mr. Heath has one more.
Okay, so just sitting in that chair, don't walk all the way back. And then I'm gonna get your other case called, okay? Forrest Null versus Audrey Turner.
Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Audrey Turner?
Yes.
Yes.
Oh, there she is. Okay. How much is owing, Mr. Hughes?
$3,988, $165 in court costs. Total amount due $4,152. It looks like she last made a $20 payment on January 6th.
Okay. All right. Ms. Turner, how are you intending on getting this paid?
Last time I told you I was moving out. So
Yes.
I have all my
Did you
stuff
move?
out. I did. I just got to give them their key.
Oh, okay. All right. So you surrendered possession. When are you going to get the key over to them?
I can do it Monday morning.
By Monday morning?
Yes.
All right. Then here's what I'm going to do rather than give you a judgment. I'm going to adjourn this out to the 18th, 2025 at 12 noon. Get the key over to them so that then they can dismiss your case out.
Okay.
Okay? Thank
Yeah.
you.
Thank you.
Thank you, Judge. Have a good weekend. I think that does it for me. Appreciate the help.
All right. Thank you, sir. Here on Vista versus Angie Evans.
Just like a very apparent complaint.
Okay. And you're Miss Evans again. All right. How much is owing on her?
Your Honor, the outstanding balance is $4,175. I do have notes that she is working with SOS.
Yeah.
I'm not clear on whether they approved the 3,000. They did. Okay.
They did not? Did they say why?
They said my income was too much with my, I had got a new job, so they said my current income was too much for the help. And on top of my son receiving disability.
Okay.
But I did agree to a forgiveness plan. And that plan was for me to pay the balance owed before and pay every rent on time before it was May, June, and July. So I paid May, June, and July on time and also paid the past due balance.
So what are they forgiving?
They're forgiving up to 1 month rent.
Oh, okay. So was there something you were supposed to sign, Miss Evans, to try to get that done, or?
I don't think anything's been signed yet, or place terms on the record. I was under the impression that the 3,000 was getting approved. That's the only thing. Do you understand that balance? So it's gonna be 4,175 minus 700 minus up to 1 month rent by the end of this plan.
By the end of July.
Right.
Yeah.
You gonna really do that, Miss Evans?
Yes.
Okay. All right. Okay, so how are we doing this then? Can COD or how?
It's gonna be in a COD, Your Honor.
Why don't I adjourn it out a week and right. I'm adjourning this to April 18th, 2025 at 3 p.m. Oh, gosh. Hold on one moment. Exactly what you want up in the middle of my docket, but I'll step off if needed. Okay. So this is going to be a COD.
Yes.
All right. So why don't I put it over to the 25th at 3 p.m. Is that right? Or the 18th at 3 p.m. and then see if we can get all that paperwork in.
Thank you.
Okay, ma'am? Here on Vista Apartments versus Contessa Brown.
For a second there, appearing for plaintiff. I'm sorry, what was the?
Contessa Brown. Not here. All right. Well, she works on that. Folks, I'm going to have to take a quick call. Court's upstanding brief recess.
All right. I guess you can have that necessity.
You may be seated. Okay. Here on Vista versus Contessa Brown.
For a second there, appearing for plaintiff.
No response. If you'd like to take a default, please raise your right hand.
No, I thought for this one, we had submitted a conditional order.
Let me see. And you have. I did not pick up on the tab. So you did. I will indicate this case is conditionally dismissed. Thank you. Court does call the case of here on Vista versus Shinelli Brown.
For a second there. Hey.
Hello, how are you? What's your name? All right. Is it Chanel? Is that how I should, yes. Even though it's hyphened? Well, if it were all together, I would have said Chanel. But with the hyphen, they're just gonna call me out in public like that. That's all right. Okay. All right, how much is owing on this?
The outstanding balance is $4,280.44.
4,000, I'm sorry.
$4,280.44.
All right. And Ms. Brown, how are you gonna get that paid? Okay.
I've been working with alcohol since I'm a kid,
Okay.
and they are confused. They just sit here, they send the check. I talked to her last Wednesday. They sent a check for the 200 we had talked about before.
Okay.
And they're also going to be paying my portion. Now, when she was talking to me, she also sat here and told me that I have not paid my washer and dryer bill, which I had no idea that that's what I was supposed to pay. I knew I was in charge of my DTE and my electric, of course. But all of this, since we had new managers, I feel like everything is just, nobody's communicating.
Okay. So you don't think you owe this money?
No, I know. I paid my rent.
Okay, so who do you, okay, I got you.
I paid my portion.
So who do you think should have paid this?
Either Alpha House is supposed to be.
Alpha House?
That's who's been paying my rent the whole entire time.
Okay. Do you see anything?
No, Your Honor, we were at court on the 28th, and Ms. Brown indicated that the full balance would be paid in full following. That was not happened at that time. The balance was $2,857.44. Now we have April rent added as well. No one has had any contact from Alpha House. I don't have anything in writing from Alpha House saying they're going to pay.
So, but one of the things she's indicating is Alpha House was paying her rent in its entirety.
I have 3 more months left.
Pardon?
I have only 3 more months left with my lease will be up, and they've been paying it since September.
Do you see anything that says that that's who? Has new management taken over?
I mean, I think that there might be a new property manager, there, but I don't, or maybe just a new, person that handles everything, but.
Second person.
But I've been in contact with everyone there, the regional director, and the notes specifically from them. I think they've been in contact and it indicates.
Well, I guess my question would be this: who was, oh boy, who was paying her rent before, or do we know?
So the notes that I had say that Alpha House was supposed to issue a check for $3,675 plus $1,088, which would have been for April. And that was as of April 2nd, nothing's been received.
Okay. So I think we're saying the same thing, because I think you're saying Alpha House was supposed to pay it. You got notes indicating Alpha House is supposed to do it. So we got to figure out why Alpha House hasn't.
Like I said, I just talked to her last Wednesday. In my house, at my kitchen table, she said the check was issued.
Did she say when it was issued?
She said it was, if they should have had it, they waited, I guess.
Okay, all right, all right. Let's do this. Let me put it out a week. 18th, April 18th, 2025, what time? 3 p.m. And let's see, hang on. I know what you're gonna do. You're gonna try to yell at me about something else. I'll just hold on. Just hold on. Yes, you are. I can tell. You started out with the yelling. Whenever it starts, sir, I know I'm about to get yelled at. So I'm gonna just preempt that. Okay. So I'm gonna set it to see if we can get this payment in. You've got to work, right? And that's why the 3 p.m. is a problem for you. I know, I see that, because nobody wears that bright a color on purpose. So, I'm sorry. Well, if you're working on a highway, I get it. No, I'm kidding. So from your work, can you appear via Zoom?
Yes.
Okay, so I'm gonna do this for you, okay? Because your name got hyphenated and I can't pronounce it. So we're gonna give you a form to fill out to let you do that. Okay? Will that work for you, or you still want to yell at me? Okay, okay. If you don't want to yell, I'm good.
Sure.
Can you? Okay, fantastic. See, this all works out. It's beautiful. Court calls the case of Huron Vista Apartments versus Naja, Washington. Hello, Miss Washington. How are you? I'm okay, I think. I don't know. All right, how much is owing?
Your Honor, the outstanding balance is $1,137. Ms. Washington has agreed to enter into this forgiveness plan COD, where she paid her April rent on time. She is going to pay her May rent and June rent, and then comply with the terms of her lease. She has applied for rental assistance. I understand she indicated to me that she was denied. And so at the end of those 3 months, which would end at the end of June, if she needs to comply with the terms, if she complies with all these terms, then they will waive up to 1 month.
Okay. Is that all correct?
Yes.
All right. Okay, so that's going to be in the form of a COD?
Yes.
All right, is it all prepared or is it not?
We can just adjourn.
Okay. Okay. So I'll adjourn it out to the 18th, 2025, at 3 p.m. Okay?
Thank you.
Thank you. See, what's her name go? That's how you don't yell at a judge. Yeah, see, that's how. I'm sensitive. No, Huron Vista versus Deanna Rogers. Hello. What's your name?
Deanna Rogers.
Ms. Rogers was here early. So, all right, how much is owing on this?
4,800.
Okay. How are you intending on getting this done?
I was trying to make sure I could, get the past due paid by the first.
So you can get by the 1st of May?
Yeah.
So your past due is almost $5,000. You're gonna pay that before the 1st of May?
No, past due was 3,000.
Say again?
Past due was 3,000.
Okay, let me ask you this, okay? Rather than working off of it, if it's past due or whatever, how much do you think you can pay by the 1st?
Other 3,000.
So you can pay 3,000 by the 1st. And then how much is your monthly rent's around 1,800?
Yeah.
So if you got that 3,000 paid, you'd still owe about $3,600. Then how are you gonna get that paid?
I don't see what you're saying.
So if you pay 3,000, right now you owe about 4,800. Okay? So if you pay 3,000, you're still gonna owe $1,800.
Two weeks after that, after the first pay of the main payments.
Okay, but after the 1st, because you're gonna get your next month's rent clicked in. So you'd owe 1,800. You'd still have 1,800 to pay, and then I have your monthly rent at about 1,837 or 39. So then if you put that together, you're gonna owe $3,600.
I'm currently trying to get help also, SOS. And
Okay.
I'm in touch with Hawk.
Okay, have you talked to the folks at Hawk?
Yeah, I'm just waiting to find out if they're gonna approve it.
Okay, so you had an appointment with them?
Yeah.
When was your appointment? Oh, you had an appointment just on the 2nd of April, right? And they haven't let you know what they're doing yet?
I got to turn in some documentation.
Okay, have you done that?
I just turned it in
When did you turn it in?
yesterday.
All right. So they're not gonna have an answer. All right, so here's,
Yeah, sorry.
Yeah.
Can you get clarification on whether that 3,000 that's being is expected from Hawk or if that is from?
that's probably a good point.
Is that for Ms. Rogers' money? I did talk to her regarding possible forgiveness plans, but she indicated to me that she's not paying her monthly rent. So,
The ones that could be paid by me and SOS.
Okay, so what Ms. Kazari is asking is this. When you told me you would have the 3,000 by the 1st, was that gonna be your money or was that gonna be Hawk's money?
My money, so SOS.
Okay, so how much of it's your money? Have you talked to the folks at Legal Services, ma'am?
Legal services? No.
Okay. I want you to give Legal Services a call because I'm a little bit worried that you're not understanding some of the things about what might happen here, okay? And so that somebody can try to organize this a little bit for you, okay? Because if nothing gets paid on this, we're gonna be at about $6,600 that's owing. And that may be too big amount to climb if we don't try to get something done, okay? So, Ann, I'm gonna give you a phone number. I need you to call and talk to the folks at Legal Services. Okay, so if you can give her Legal Services number. And then I'm going to adjourn this out 1 week to the 18th, 2025 at 3 p.m. Okay? So I'm going to adjourn you out 1 week, 3 o'clock. I'm going to give you the number to Legal Services. I want you to give them a call, okay? All right. Thank you. And make sure also if Hawk has an update for us, then let us know, okay? Thank you. Evergreen Apartments versus Lavinia Kendricks Haynes. Where is she? There, oh, there she is.
Hello,
Hello, how are you?
I'm okay.
All right. Where are we on her case?
Your Honor, the outstanding balance is $2,998. I understand that Ms. Kendricks, Haynes has been approved for the full amount.
Okay.
And they released the payment, so it's gonna be 2 weeks before we get it.
Okay. To the 25th. All right. That work for you?
It works.
Okay. April 25th, 2025,
Well,
12 p.m.
Okay, thank you.
Okay, thank you. You have a great weekend.
You too.
All right.
Thank you.
Glencoe Hills versus Angela Stoker. Hello. What's your name? All right. And how much is owing us?
$870.06.
All right, you know the question. When do you think you can get this paid?
Hawk approved it.
Eight.
Yeah, they said 3 days ago. Yeah, 7 days.
I see that, Your Honor.
They have approved, so everything but 50 is approved, is that the deal?
That's the late. They just put that on there yesterday.
All right. They can't waive that late fee if it's been approved? Okay, well, here's what I'm gonna do. I'll adjourn this out. Well, when did they say that? Do you have that the check was released or you don't know?
Yes, Your Honor, we received it today from Ms. Sykes today, stating that a check for $820.06 was mailed on April 9th.
Okay, so here's what I'll do. Let me adjourn this then to April 25th, 2025, 12 noon. If that $50 is still there, then come back and then I'll have to make the decision on the 50. All right. Fair enough?
Yeah.
All right, take care. Gulfside Lakes versus Patrice Haywood. Hello. All right, where are we on her case?
Legal services contacted me, indicated that there is a commitment letter that's issued for that full amount.
Oh, okay. So why don't I put it over to the 25th, 2025 at 12 noon? Okay. How are you doing otherwise? You're okay? All right. Keep smiling. Have a great weekend. Hamilton Crossing 1 versus Crystal Stanley. Crystal Stanley? They did not check in. If you wish to take a default, you can raise your right hand.
No, I don't believe this is her.
You want to know what? Hold on. This might be the same thing. I missed. No. It's a writ hearing. It was no writ without a hearing, correct? Has the 392 been paid? Well, I had, when the writ was submitted that 174 of the 392 had been paid.
Yes.
And did they finish the balance? Please say yes.
No, I don't see that anything else is been paid. You can pass this one out.
All right, yeah, pass it. Court calls case of Hamilton Crossing 2 versus Tiffany Roots. Tiffany Roots?
Yes, I'm here.
Oh, there you are. Okay. Okay, how much is owing on this case? $2,081.
I'm sorry?
All
No,
right. Pardon?
no. I have a receipt right here that shows I owe $760. Where did the 2,000 come from?
Hold on.
So, April rent was added.
April rent got added to your ledger, man.
Okay, April rent has been paid. I have a receipt with today's date on it that shows 760.
Okay. Okay, so hold on. Did you make a payment today?
Yes.
Okay, you can hold that up all you want. My eyes, I can't pick that up. All right. So, all right, then let me do this. So how much do you owe now? You, according to your thing, your receipt?
$760.
Okay, so if I work off of that figure, when can you get that paid?
Okay, so that was it was only left behind and unpaid because of the approval from the Department of Human Services. There was an
Okay.
that they were supposed to pay it, but there was an error made. So I have an appointment to come up there and speak to my worker today to find out what the holdup is for them to pay the final amount. I do have that amount set to the side so that I can, if they are not going to cover it,
If
then
they're not going to do anything. All right, so let me do this then. I'll adjourn it out a week.
Okay.
Let you try to figure that out and let's see where we are, okay? Fair
Okay.
enough?
Yes, not a problem.
April 18, 2025, 3 p.m.
Okay. Thank you.
Okay?
Yes, thank you.
Thank you. Have a great weekend.
You too.
And then Hamilton Crossing 2 versus Sunji Sprites. That matter is, oh, you're here. I didn't know you had been sitting there waiting. They have moved to dismiss your case.
Right, because I got an email to care of it.
Okay, well, so your case is dismissed. All right, thank you for coming down. Okay, you have a great.
Copies of.
The dismissal? You waited all this time. I don't usually do this. I'll get you a copy. All right. Okay, you take care. Have a great weekend. On the other one, okay. Dizak Enterprises, AKA Motel Manor versus Malcolm Hanks. And Alyssa Robbins, I'm sorry.
That's okay. John and Mitch, on behalf of the plaintiff, my right is Casey Zach, who is representative from the plaintiff. I've not received a response, and the defendants are no-show. They didn't show the first hearing.
All right.
This is a non-payment rent case.
Raise your right hand to be sworn. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth. Oh, God. All right. How much is owing?
How much is currently owed?
$7,760.
$7,000.
Oh, sorry. Oh, it's, court fees, $7,971.40.
Let me break that down, Your Honor. $11.40. Court costs $7,760 for rent to retain for a total of $7,970.
All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. And I have signed your judgment.
Thank you, Your Honor.
All right. Thank you.
Thank you.
I see that right now.
This gentleman walked in after his case was called.
Oh. Yeah, he's gonna have to do that. Court calls the case of Arbor House Apartments versus Jasmine Branch.
Good afternoon, Your Honor. Mark Land on behalf of the plaintiff.
Your name? All right. And how much is owing on this?
$9,341.24 in rent, $180 in court costs, total of $9,521.24.
Well, they probably, from the last time, they would have added April rent in. And you have not received a $2,000 check yet. Is that right?
No, that's correct, Your Honor. Your Honor mentioned that at the previous hearing, that $2,000 was paid into escrow. It was being released to the plaintiff. You didn't need an order from me to have that released.
Correct. It's been released, but it didn't get released until the 8th. So
very good.
Been trying to contact me for over like weeks. Like I just got an email from her today. She said nobody's been answering the phone, so they can't.
Nobody at Hawk has.
No, nobody.
Has your client been responding to Hawk?
Yes, Your Honor.
Okay, because she's got an email saying
I just got it again. She said that they haven't been answering emails or calls.
they haven't been answering emails or calls.
Hawk is welcome to contact me, but I did reach out to my client after the last hearing to ask if she had gotten any contact from Hawk, and trying to pull up that email now.
Name?
Her name is Kathleen. Kathleen?
Kathleen.
Yeah, I was
Sorry,
just
I'm not
talking to her
seeing,
at
I'm not
1:20.
finding that email, Judge. I'm sorry.
All right, here's what we're gonna do. Ma'am, we're gonna give you Mr. Landau's email, and we're gonna need you to forward that, if you would, to him. I'll adjourn this out 1 week to the 18th, and let's see where we are.
Okay, thank you.
2025, April 18, 2025 at 1 p.m.
Judge,
Okay.
one other matter. My
Sure.
notes indicate that Miss Branch indicated that she would be paying $1,500 out of her own pocket by April 4.
That is true.
That has not been received. I'd like to find out what the
I won't
status
get
is.
in until next week. In fact, I just started another job. So
You won't have it until the
the
14th.
next time,
I'm sorry,
the next court date I'll have.
the
I'm trying to
18th
have the whole-
by that time?
Yes.
Okay. All right. So she didn't get it by the 4th. It's a paycheck, right? So it's the 18th that she'll get it. So she should have it on the date that she comes back.
Yes.
Okay.
So I'm gonna
Very
try to
good.
have the whole 28. And then I'll
Okay.
have to work on
I will look for Miss Branch's email over the next 3 or 4 days.
You have a-
Yeah, hold on. We're gonna give it to you. Okay. Thank you. Court does call the case of Westbourne Family Trust versus Daryl West.
Mark Land on behalf of plaintiff.
Mr. West, state your appearance. Just state your name. You gotta unmute first, sir.
Daryl West, present.
Okay, where are we on this case? I'm afraid to ask.
Judge, this is a termination of tenancy action. My client is the owner of property. Mr. West is the trustee and the trustee's brother. He's been living there a lot of years, and they are estranged. And my client just wants to get the property back, sell it, and that's pretty much the long and short of it.
It's not the long and short of
All
it.
right, Well, I've read everything that you submitted, Mr. West, much of it irrelevant to these proceedings, quite frankly. The only thing that I have that may be of some relevance, is there a matter pending in the Court of Appeals?
Absolutely. Case number 375000.
Your Honor,
375.
Mr. West filed a motion to stay the eviction case that was denied.
That's not
Oh, in the
exactly
Court of
correct.
Appeals?
It was denied with the Court of Appeals.
All right, thank you.
Judge, that's not exactly correct. It's a misleading statement. Actually, what happened was filed an interlocutory appeal, and the circuit court went ahead and ruled while that interlocutory appeal was pending. Therefore, I filed a right of appeal and let the interlocutory appeal be dismissed. And it was on that basis that the interlocutory appeal was dismissed based on the current pending case. And there's still on the docket a motion.
But there is no stay of these proceedings.
There is a motion for stay of these proceedings on the 375000 case.
All right, well, you're gonna have to get to them because I don't see here that I've got a tribal issue. I am not gonna stay these proceedings. And so if the Court of Appeals wishes to stay it, then the Court of Appeals can stay it. Mr. Landau has indicated that they denied it. You're indicating something different.
Am I
than
entitled to
that.
a jury trial?
If I don't have a tribal issue, no, sir.
Judge, there's promissory estoppel, there's quantum meute, there's a written documented contract documented and subscribed by the plaintiff.
All of those are not tribal issues that grant you possession of the premises, sir.
The document subscribed by the plaintiff grants me premises occupancy.
I disagree. It's not a tribal issue for me, sir. You show me nothing that gives you claim to those premises.
I submitted the document where the owner of the property granted me living arrangements to the property. That's in the file.
For how long, sir?
For the balance of my life.
I do not see anything in here representing a life estate. If you are claiming that you have a life estate, then you need to file the appropriate paperwork.
It's not a life estate, Judge.
You need to file the appropriate paperwork in the circuit court so the circuit court can make a determination as to whether or not you have a life estate of some type on the premises. But I do not see that. I do not see any defect in the notice which has been provided by the plaintiff in this case. I have nothing to try.
Please address their complaint. Their complaint clearly files misleading information. In item 2, counsel says there is no other pending or previously filed document or court actions. And in fact, there was a circuit court action and it's under appeal now. Therefore, that's misleading statement. Furthermore,
which has no relevance to this court and its decision, because this case would not have gone up to circuit court.
This case was already in the circuit court on a parallel.
No, sir. This case is a district court case. This case, regardless of what plaintiff said, would have been filed and resided right here before me.
Judge, can I go on further to the complaint?
Not if you're going to waste my time.
I'm not.
Yes, you are, but go ahead.
In section 8, plaintiff and counsel suggest to this court that the property owner has maintained that property in accordance with state law as it's a residential unit. That is absolutely a false statement. She has stated in a statement of facts and a motion at the circuit court that she hasn't communicated or been in contact with the resident occupant, Daryl West, in 10 years. She has not maintained the property in accordance with Michigan law. Furthermore, because I had to maintain it, I spent $25,000 of my money to keep the property maintained. She has completely falsified the complaint, Judge. She did not provide adequate maintenance to the home in reference to Section H of the complaint. That's a false statement. There's 2 false statements provided in the complaint, and the court should order a show cause hearing at the very least and should actually dismiss this case.
Are you done?
Yes.
It still is not an issue related to the termination case. If you believe that there's a money case that needs to be filed, then you may do so.
Judge, one last point.
I thought you were done.
I was until you made that comment.
Sir, I might suggest that you get yourself an attorney to represent you.
Can you adjourn it?
Because the termination
While I do?
case, nothing has been filed before me that gives me anything to try as a reference to termination case. I'm going to keep saying it. There's nothing that you're saying to me right now. I've let you go on far longer than I would normally let anybody else go on regarding this. If you have one more thing to say to me, you may, and then I'm going to have my word.
Have your word, Judge.
Court finds that there's no tribal issue as to the issue of possession in this matter. I will grant judgment to the plaintiff for possession with a writ to issue in 10 days.
Wow.
From the signing of the order.
Judge, as much as I appreciate the court making that ruling, I'm willing to give Mr. West additional time. My client is his sister, and even though they're estranged, she knows that this is going to create a hardship for him. He is an amputee, and it's going to take him some time to vacate. I want to give him the comfort of some additional time.
So here's what I'm going to do, Mr. Landau. I understand that. So I'm going to issue my judgment. What the parties work out, you can work out. But I'm going to issue the judgment as I pronounced it.
Very good.
Thank you.
I'll submit the judgment.
Wenfu Zhao Trim versus William Dunleavy. Okay. Well, they tried to find each other. Miss Zeri, did you? So I'll call the case of Hamilton Crossing versus Crystal Stanley.
Your Honor, this is a rate hearing. I just want to provide clarification for the court. The judgment that was taken was for $392. There was a payment of $174 that was made at the time that we received the request for the writ. I understand that the defendants did try to make a partial payment of $124. And that, just so everyone's clear, that was not the full amount. They didn't want to put them out and also accept it.
So there was 174. They tried to pay 124.
Additional, right?
Additional, which would have been 298. I got you. Okay.
So that we're left a balance of $98. So they're,
Yeah,
so, but they're not here, Your Honor.
I know. I got you. All right. Writ can issue.
Thank you, Your Honor.
Thank you.
Good weekend.
You do the same. Is it called? Sal Trim and Julie, yes, is it Yasu versus William Dunleavy. Hello. Hey, who do I have here?
Good afternoon, William Dunleavy, Linford Trim, and I'm Curtis.
Okay. All right. Where are we on this case?
Bill has moved out of the house.
Okay.
He's left it in good order. He's done a real nice job of cleaning up. He's not out of the garage yet and or the driveway. But you know, that's not a critical issue right today, because we're still paying the repair of the house and everything, the inside. So we're not, that's fine. And
he's out of the premises.
He's out of the house, but not the garage.
Got it. Okay. So what do you guys want me to do?
What we'd like to do is get a judgment ordered for what we.
Do the parties agree on how much is owed?
Yeah, I think so. At this point,
Then all you need to do is fill out a judgment form, submit it for me for signature, and I'll sign off on it. If you guys agree on the amount.
okay, it's 34 900.
Do we have to submit that right?
34,000.
34,000.
My jurisdictional limit for the issuance of money judgment 25.
That's what you told us the last time.
I know, and it still is.
And you said though that we would, you said you would work something out on the balance. Would be able to work something out on the balance.
I don't know that I can work anything out. All I can do is 25,000 plus cost.
No ifs, ands, or buts. I stipulate to at least that amount for sure. I mean, it's more than that. So I know that if that's what you would do, fine.
Well, we can
I'll
stipulate.
sign right now on.
We can stipulate to 34 900 38, can we not? And
That stipulation, everybody wants to use legal words. I don't know that you guys agree on that. I cannot issue a judgment for that amount. I told you that before you came back here today.
Oh, the next question.
Sure. If you want me to send you to circuit court for it, I'm sure there's a judge up there that'd be more than happy to hear this.
Does it mean if the 25 were to happen, that it would mean that is it? It's
That's it.
whatever, and it's done, that they wouldn't have reached a further amount. I don't necessarily want to do that to them. Or is that just
That's a legal question I can't answer as to what one's remedies might be. So what do you folks want me to do? Yes.
Because last time probably I didn't fully understood what you said. At the end, you said the maximum you can do is 25,000. Then you can work something else for both. But I was wondering if it's possible, this 34,900 can be split into two
orders. Yeah, that's what she's asking. Two orders.
I understood what she said. You don't have to try to man speak it for me. I clearly understood what she said.
It's possible, but I don't.
I can't do that.
So, okay. I guess I don't quite understand if if I only, now is there any other way that I can get the full amount back?
Sure. You can file an action in circuit court, which would have jurisdiction to issue a judgment in excess of $25,000. Because possession is no longer an issue. So you could file a complaint in circuit court and the circuit court could issue that judgment.
So I agree that today we sign us that 25,000. Can we do that later on top of that issue the additional amount?
Say again?
So.
I can't, I'm not splitting two judgments. I'm not issuing two judgments.
I understand. You said if we want the full amount back.
Then you can take it to circuit court. All right, look, here's what I'm gonna do, because I've got other matters that I gotta deal with.
We're good with that.
I don't know what you're good with, because nobody has said anything.
The maximum.
The 25,000?
Yes.
Okay, and you agree with that? Okay, you guys need to fill out a judgment form. I'll enter the judgment for the 25,000 monetary judgment for that amount, for the $25,000. I need a judgment that I can sign. So you can go out to the front counter, get a judgment, fill it out, get it back to us, and I'll sign off on it.
Okay,
Just read that.
Hmm?
Read. How do we bring it back? That's all.
do we give it to her?
You can give it to the clerk's office. They'll be more than happy to take it for my signature.
Not.
You don't have to come back.
I see, just give it to them.
Really, you don't have to come back.
Okay, my wife is asking, what about, can, in the order, can you enter what Bill agrees to pay back in terms of monthly?
Folks, square peg, round hole. I have $25,000 that I can do.
Oh, yeah.
I told you to do it.
Payment plan is what she's asking.
For the payment plan for the 25,000?
Yeah.
You can put that under yes, you can put that in the judgment form.
Okay, all right.
Whatever he's gonna pay per month or however he's gonna pay the 25.
Okay, last question, Your Honor. Is it possible that, even though we're maxed out at 25, can you mention in that order that the full amount that was owed was the 30?
Square peg, round hole. No,
Okay, I understand.
thank you.
All right, well, thank you for your time. We appreciate it.
Thank you. Maple Heights Apartments versus Hussam Al-Musawi.
Your Honor, Alex told me to carry on behalf of.
Sir.
So glad you were here to witness that. All right, folks, where are we on this?
Yes, so since the last hearing, I've talked to my client. We've done some ledger adjustments, including crediting late fees and some other concessions, due to the nature of the balance. All that's remaining for rent is $260.81. There was no payment made in August of 2024, so that's where that balance comes from. The full amount, no payments at all were made. His rent at that time was $481.
Okay, so what he owes right now is $260.81.
Of rent plus work costs.
Okay, and your court costs are how much?
$170.05. So $430.86 is what I show.
Sir, what do you say to that?
Oh, I have the receipt for that one. For that one, they were missing on.
You guys can't go through a ledger and figure it out?
So I get a phone call, nobody approached me.
Pardon?
I get a phone call, nobody actually approached me first.
Did you go get a ledger sheet?
Yes, you gave me one last time.
Right. And you say you have a receipt for that?
Yes, sir.
Did you give him a copy of your adjusted ledger?
I called him on the phone to discuss it and he was not interested in discussing. So I don't know if the property gave him,
Why weren't you, if she called you, why weren't you interested in talking about it?
Sir, she said that it went down from $20-some to $260. Are you gonna pay that? I said, for what? This is the first I hear about.
You wanna know what? No, here's what we're gonna do. I'm gonna set this for a final settlement conference over to $260 for April 22nd, 2025, 9 a.m. If you guys have to, at that point, I'll have the time. If you have to sit in the room, with me, you'll sit in a room with me. It's often not a pleasant experience, but that's what I have to happen. All right? Next time they call, just talk to them. Just talk to them. You don't have to agree, just talk to them. Otherwise, I can't do anything. Have a great weekend. And counsel, thank you for being here, for witnessing that case before. Because nobody would believe. All right, take care. I think, unless I have to go back on, but I don't think I have to. I'll just do it as an adjournment, because I wasn't gonna do anything, but if I have to